Welcome back to Adam's Everything EV. I have an extremely special guest, and the Fisker saga just continues. Steve Berman from Hagens Berman, thank you so much for coming on the show.
Thanks for having me.
I really appreciate it. We've got kind of a bad situation, really, overall, when it comes to Fisker ownership. And today we're going to talk about the holder rule and arbitration. Is that right?
That's correct.
Okay, wonderful. Can you maybe introduce yourself, do a little background, and then explain what you're doing for Fisker owners?
Sure. I'm Steve Berman. I'm the managing partner of a nationwide firm that specializes in class actions. And we've done a ton of the largest auto defect cases in U.S. history, including once I got a couple $1 billion settlement against Toyota, and they wound up retrofitting almost all their vehicles with what are called brake overrides, which caused the unintended acceleration problem many years ago to go away. So that's what I do.
Okay, wow. So that's a big one. And I'm sure you've been involved in many other big ones throughout the years. But as far as Fisker goes, we've got maybe a Chase related thing. Is that right, with the arbitration?
So here's the situation with Fisker. Because Fisker is in bankruptcy, you can't really sue Fisker. And so most of the times, car owners would be out of luck. But there's a little known law that one of my partners reminded me of, because I didn't remember it from law school days. It's called the holder in due course rule. That says if you're a bank or a financer and you're deeply involved with the promotion of the vehicles, you can be held liable to the same extent that the car manufacturer can. So claims of breach of contract, breach of warranty, misrepresentation that could be brought against Fisker now could be brought against the bank.
And then specifically with reference to Chase, they had the Fisker Finance. So are we just working within Chase?
Right now, we know that Chase did the Fisker Finance, and in their contracts with you, they admit they're a holder in due course. So they've admitted it, it's in writing, they're responsible. Okay. I haven't had other finance companies brought to my attention yet, so I don't know if they're a holder in due course. So right now, the only claims we have filed are against Chase.
Okay, and then that's exactly where we need to go next. If I'm a Fisker owner and I financed with Chase, because that's definitely part of this situation, I need to have financed with Chase. What are the next steps for me? And that involves you directly, correct?
Yes. Well, it doesn't have to, but if you were representing folks, and folks can pick other lawyers, but in your agreement with Chase and Fisker, there's an anti-class action clause. It says you can't bring a class action and you have to arbitrate. And so the only way to get any resolution is to file a claim in arbitration against Chase, which we are doing one by one. So if you can't bring a class action, we'll just file 1,000 or 2,000 or 3,000 claims and resolve the matter that way.
So those are being set up directly with you, and I'll put the website on the screen, and they just reach out to you and then you help from there. What other actions does an owner need to take if they're going to go with you guys?
Nothing. Just review our agreement. We'll file an arbitration case once we get all your information, and we're off to the races.
Great. So I'm Pittsburgh area, at least geographically, and we had a guy, Edgar Snyder. We don't pay. You don't pay unless we get money from you.
Russell Wilson.
Yeah.
Good luck with that.
Oh, yeah. Well, let's hope so. Definitely fingers crossed there. And a lot of excitement around that as well. But there's no fee unless we get money for you. That was the Edgar Snyder line in Pittsburgh. Is that the deal here?
That's the deal. If we don't win, then you don't owe us anything.
Okay.
But we're going to win. Okay? Because these cars are a mess. And we've heard so many, I've never heard stories like this. Again, I've been doing auto defect litigation for decades. And, people can't use these cars. There's no software updates. Some of the cars are bricked. I mean, it's an outrageous situation. So I'm not sure what the defense will be once we get going.
Great. So it sounds really simple. And that's really why I wanted to have you on here, because this is kind of is there any reason why someone wouldn't want to do this? If you
No,
find
it's simple. So the irony of this is the companies started using arbitration clauses because they didn't want class actions. And they told the courts and Congress, wow, it's so much easier to do arbitration. It's faster. There's not all this discovery. It's a simple procedure. And so now what many firms are doing is we're turning the tables and we're saying, okay, you're right. We can't get every single Fisker owner because it's not a class, but we can get thousands and let's do this simple procedure. So we're turning the tables on the bad guys.
Now, in the event that, let's say, you put 30, 50, 100 of these through, is there a motivation to get a kind of a base settlement for folks that do this, or is it just going to have to be individual?
I would think eventually, if we keep winning, that Chase would want to set up a resolution program, or they could go the other route. This is what happened in one of my Amazon cases. I had this huge antitrust case against Amazon, and they have an arbitration clause. So there were 75,000 arbitrations filed.
Wow.
And Amazon said, oh my God, this is horrible. Forget it. Okay, you can bring a class action. So if we get enough cases going and we keep winning, Chase will have to do something different.
Okay, so a class action is obviously not the option as far as the law is written right now, but they could make a decision to allow that.
They could.
Okay. I never thought I would be digging this deep into automotive legal stuff, but here we are. I've got some questions from potential owners and people in different situations. You want to try to field some of those?
I'll do the best I can.
I really appreciate it, Steve. What happens to the vehicle if I win?
Well, it depends what our remedy is. So if one of the remedies under some of the laws would be a buyback, and so they would take the vehicle back and you get your money back.
Okay. It sounds like a really good resolution, especially with some of the values out there now. And like you said, all these problems. Now, what if I want to keep it?
If you want to keep it, then your damage would be the difference between what you were promised. But let's say that you paid $80,000 for this car, and because of all the issues, it's really worth a lot less, which we would figure out how to monetize, and you would get that difference.
Okay, so there's a situation where an owner could maybe make that decision.
That's right.
Great. What if I already have an arbitration judgment? A lot of these are creditors now in the case, and like you said, we're under a stay. We can't do anything. What do they do?
They would have to file a new claim against Chase.
Okay.
And I think what you would do is file the claim to enforce the judgment.
Against Chase.
Yes, take that and say, Fisker's been found liable. You stand in the shoes of Fisker for this, so now you're liable. I think you'd have to do that.
Is that something you would want people to reach out to you to solve or go their own route?
Well, they need a lawyer of some kind to solve.
Okay.
So they're glad to contact us.
Great. What if I refinanced? Let's say I got in this situation and I needed to get out and try to find some kind of resolution with all the value changes. Do they have? I'm kind of in this boat too. I sold my vehicle, but I did finance with Chase. Do I have a claim with you?
You do, because your vehicle is not worth the same as it was when you financed it with Chase. It's just not. The market for these things, sorry to tell you, and you know that, is dumping. So you would be entitled to the difference between the value now and the value as it should have been, absent the wrongdoing. And I think you could file a claim against Chase for that.
Okay, and then final thing in that vein is different banks. If I financed with someone else, do I need to investigate with my own bank as to whether this holder rule is in their terms, or does it need to be there? Is it kind of a stated thing, or
no? They have to put it in there.
Okay.
So if you send us your agreement with your bank, we can see if it's in there.
Great. So they just reach out to you just like they would be with Chase, and then you can take an opportunity to look at it potentially.
Exactly.
Okay. Steve, that's it. What are your thoughts on Fisker as a company and as a car? What are your thoughts here?
Well, I feel sorry for all you guys. It's funny. I wanted to get a Rivian.
Okay.
And I waited in line. I went to go pick it up last year. My wife is a super smart person. She goes, I'm watching the money that Rivian has in the bank. they're going to go bankrupt. I refuse to let you buy a car. And a year from now, you won't be able to service it. And it won't be worth anything. So she exercised the family controls. And I'm glad she did. And so I feel bad when people have these cars.
Any other thoughts at all before we go?
No, I think we covered it. Thanks for having me on. Glad to
Steve,
get
I
the
can't
word.
thank you enough. Make sure you reach out to Hagens Berman. I'll leave the links and the website, and someone will be in contact with you right away. Is that right?
As soon as we can. There's a lot of people calling us.
Then that's the last thing we'll touch on before we go. Have you had an outreach so far?
Yeah, we've had 1,000 people call us so far.
Wow.
So
Okay.
that's a lot. Yeah.
So join the ranks. Hagens Berman. Steve, thank you so much for joining me today, and we'll talk soon.
Okay. Thanks, man. Good to meet you.
Nice to meet you as well. Take care.
Hey, smash the like button.
Thank you.